Officer, what law did I break? You need to leave now. I'm only waiting for my daughter.
Dad,
Maya.
maybe he's running late.
Stop right there.
That's it. That's the moment.
He never resisted.
Write that he pulled away first. Make sure it's in the report.
Is that your voice? This changes everything.
Say he resisted.
It's over. We won.
No. It's not about winning. It's about making sure it never happens again.
Approved.
Julian Cross was only waiting for his daughter at a bus stop when Officer Brett Harlan walked over and told him to leave the neighborhood where he had lived for 10 years. Julian calmly asked what law he had broken. Harlan gave no answer, locked his hands behind his back, and wrote in the report that the black father had resisted. But the camera on the bus recorded everything, and the badge in Julian's wallet revealed he was a federal prosecutor who specialized in investigating civil rights violations. 6 months later, the city paid him $6.8 million. If you believe dignity has nothing to do with skin color or a uniform, stay with Julian until the end. Julian Cross had spent his Friday afternoon the way he spent most Fridays, seated at a federal desk in a building that smelled of old carpet and fluorescent lighting, working through a stack of contract fraud depositions that the average person would abandon after the first 30 pages. He was 40 years old, methodical by nature, and had trained himself over 2 decades of legal work to keep his voice flat, even when his instincts told him something had gone badly wrong. His wife had died 5 years earlier, and since then he had rearranged his entire schedule around one priority: being present for Maya, their 13-year-old daughter, who had inherited her mother's sharpness and her father's quiet stubbornness in equal measure. That Friday, his car was at the mechanic, and he left the office an hour early so he could walk the 6 blocks from their house on Alderman Street to the transit stop on Briar Avenue, where Maya's after-school debate club always dropped its students. He carried a worn leather document bag over one shoulder, wore a dark jacket that had been through 3 Ohio winters, and stood beside the posted schedule the way any parent might. Patient, unhurried, watching the light shift on the storefronts across the street. Maya called to say the bus was running 15 minutes behind because of a detour near the high school, and Julian told her to stay seated with her teacher and that he would be right there when she arrived. He checked his watch, looked up and down Briar Avenue at the early evening foot traffic, and settled back against the transit shelter with his bag between his feet. The street was ordinary in every way. A hardware store with its front gate still raised, a woman walking a dog past a barbershop, a pair of teenagers eating from a paper bag on the steps of the laundromat. Nothing was closed, nothing was cordoned off, and no alarm of any kind disturbed the ambient hum of a neighborhood winding down toward the weekend. A patrol vehicle pulled to the curb before he had been standing there 10 minutes, and Officer Brett Harlan stepped out with the particular deliberateness of someone who had already decided what kind of conversation this was going to be. He asked Julian what he was doing in the area, and Julian answered that he was waiting for his daughter. Harlan said someone had called in a suspicious person near the stores and that Julian needed to move along, and Julian, who had spent his professional life learning exactly how legal authority worked and precisely where its limits lay, responded with a question that was quiet and precise. Was he being detained, or was he free to go? The question did not land as a threat or a provocation. It landed as what it was, a person asking to understand his legal status, and it was enough to make Harlan's jaw tighten visibly. Harlan demanded identification without naming any specific crime or articulable suspicion, and Julian produced his driver's license, handing it over with both hands visible, and his posture deliberately open. He did not mention that his wallet also contained a federal service credential. Not because he was hiding it, but because he believed the rights of any person standing on a public sidewalk should not depend on what title that person held. He watched Harlan run the license, watched the data come back clean, and then watched Harlan reach for his radio anyway. The backup unit arrived within 4 minutes, and the second officer, a younger man named Colin Webb, who had been on the force less than 2 years, parked behind Harlan's vehicle and walked over with the careful posture of someone still learning how to read a scene. Julian had kept his hands in front of him the entire time, had not raised his voice, had not stepped forward or back, and had done nothing that a body cam or a witness or a judge would later describe as anything other than compliance. Colin looked at the man standing calmly beside the transit shelter and then at his senior officer, and whatever he saw in Harlan's expression told him this was not a moment to ask questions. Harlan told Julian to turn and face the shelter wall, and Julian asked for the legal basis of the arrest before complying, which was not obstruction. It was the kind of procedural question any attorney in the country knew how to ask and had every right to voice. Harlan did not answer, stepped forward, took Julian's right wrist, and locked a handcuff around it before reaching for the left, and Julian did not pull away, did not resist, did not do anything other than state aloud the exact time, the exact location, and his formal request that both officers preserve all body cam footage from the moment of first contact. Harlan snorted and said he talked like a lawyer, which was accurate, though he did not yet understand how accurate. The document bag was searched and found to contain deposition transcripts, a legal pad covered in margin notes, a water bottle, and a phone, and nothing present was illegal in any jurisdiction under any statute. When Harlan reached the federal service card in the wallet and held it up, he told Colin it might be fraudulent and set it aside without making any attempt to verify it, despite the fact that any dispatcher could have confirmed the credential's validity in under 90 seconds. Julian asked in the same measured tone he had used throughout whether he could place a call to the person who would otherwise be waiting for Maya when the bus arrived, and Harlan told him that would have to wait until they were at the station. The bus carrying Maya pulled to the stop 7 minutes after the patrol car carrying Julian turned off Briar Avenue, and the teacher chaperoning the club waited with Maya for 20 minutes before deciding no one was coming and driving her to a family member's house. Julian would not learn any of this until nearly midnight. The arrest report Harlan filed listed 2 charges: obstructing official business and failure to comply with a lawful dispersal order, and neither charge explained how a man standing legally at a public transit stop had been subject to any dispersal order in the first place. On the drive to the station, Harlan reached over and switched the audio function on his body cam to silent, then looked at Colin in the rearview mirror and said they needed to get their story straight before anyone upstairs looked at the file. The desk sergeant at the Bellwether Police Department's central booking station ran Julian's credential through the Federal Registry within 8 minutes of his arrival, and came back looking like a man who had just realized he was standing in a field that might be mined. A federal prosecutor, not a paralegal, not a law clerk, not a retired magistrate, but an active assistant United States attorney who handled civil rights violations for a living, was sitting in intake wearing handcuffs applied without documented probable cause, and the only thing separating the department from a formal federal inquiry was whatever paperwork Harlan had already submitted. The sergeant found Harlan in the corridor and spoke to him quietly, and the conversation lasted 4 minutes, and at the end of it, nothing changed. Releasing Julian immediately would have required someone to acknowledge that the initial report was wrong, and no one in the chain of command was prepared to do that within the first hour. Harlan had already filed a preliminary account, stating that Julian had jerked his arm and attempted to leave the scene, a description that conflicted with what Colin had observed, but that Colin had not yet been asked to contradict. The department entered a holding pattern it dressed up as verification, and Julian spent 11 hours in a temporary detention cell, while that verification produced no new information that had not been available within the first 15 minutes. He did not demand special treatment. He asked once to be allowed to call someone who could reach Maya and confirm she was safe, and after a delay of nearly 2 hours, he was given a 3-minute call that told him she was at his sister's home and unharmed. After that, he sat and did what his training had taught him to do in situations he could not immediately control. He observed, he cataloged, and he said very little. He noticed that the time logged for his arrest on the incoming paperwork was 19 minutes later than the actual moment Harlan had put on the handcuffs, which was a gap large enough to obscure the portion of body cam footage during which the audio had been silenced. He noticed which officers walked past the cell door and how each of them reacted when they were told what his job was. He noticed the difference between the ones who looked uncomfortable and the ones who looked like this was ordinary, and he understood that both reactions were evidence of something. The discomfort of people who still registered the gap between what should happen and what was happening, and the indifference of people who had stopped registering it entirely. Shortly after 3 in the morning, a representative from the federal prosecutor's office arrived with documentation confirming Julian's identity and employment status, and he was released with a notice to appear because Harlan had declined to withdraw the charges. Police Chief Graham Whitlock appeared in the corridor before Julian reached the exit doors, speaking in the low, warm tone of a man accustomed to smoothing things over, calling the night a regrettable misunderstanding, and suggesting that the department could make the summons disappear quietly if Julian was willing to let the matter resolve without public disclosure. Julian told the chief that any resolution needed to go through proper legal channels and needed to be documented in writing. And within 45 minutes, the department had issued a press statement describing Julian as an individual who had caused a disturbance in an area under active security monitoring. The press statement moved quickly through the local news cycle in the way that official statements from law enforcement tend to do. Treated as factual, reprinted without context, published alongside a photograph of Julian in handcuffs that had been taken at the scene by a bystander, and that showed none of the preceding interaction. Within 24 hours, a segment of online discussion had turned the image into a debate about whether Julian had used his federal status to intimidate the officers, a framing so inverted from what had actually occurred that it took Julian a long moment, reading it from a kitchen chair at 6 in the morning, to be certain he was understanding the words correctly. His supervisors at the federal office placed him on administrative leave with pay, not because he was under any suspicion, but because an open dispute between one of their attorneys and a municipal police department created a conflict of interest the office could not ignore while the matter remained unresolved. The distinction between being suspended and being given paid time off while a situation sorted itself out was technically clear, but it had the effect of removing him from the cases he was actively working, which included 2 contract fraud prosecutions and a civil rights complaint against a county sheriff's office that had been building for 3 years. Maya was sitting at the kitchen table doing homework when Julian came home that morning, and she looked up and asked why the police had taken him away when all he had been doing was waiting for her. Julian sat across from her and thought carefully before answering, because he knew she was old enough to understand a complicated truth and young enough for a careless answer, sir, to settle into her and calcify over time. He told her that a person with authority could still make the wrong choice, and that the system was supposed to have mechanisms for correcting those choices, and that what they were going to do now was use those mechanisms exactly as they were designed to be used. Naomi Price agreed to take the case on the condition that Julian remove himself from any professional involvement in matters touching the city of Bellwether for the duration of the litigation. She was not going to win a civil rights case, while opposing counsel argued her client was using federal resources to conduct a personal vendetta. Julian agreed, formalized his recusal the next morning, and Naomi sent the city a preservation demand covering both officers' body cam systems, the patrol car's dash cam, traffic cameras at the intersection, dispatch logs, real-time incident reports, and all communications between Harlan and his supervisory chain from the 2 hours preceding and following the arrest. The city's response arrived 8 days later and stated that Harlan's body cam had experienced a malfunction during the relevant time frame, resulting in the loss of audio data. Naomi read the response twice, set it down on her desk, and did not say anything for a moment. Then an employee of the City Transit Authority called Julian's personal phone and told him that the bus running Maya's route had a mounted camera positioned directly at the Briar Avenue stop, and that the footage was still in the system. Naomi moved for a preservation order before the transit system's automatic overwrite cycle ran, and the order was granted 48 hours before the footage would have been deleted. The video had no synchronized audio, but it had something worth considerably more in a case where the central dispute was about physical movement, continuous, unobstructed visual coverage of the entire stop, from the moment Julian arrived until the moment the patrol car drove away. It showed him standing beside the posted schedule, with his bag between his feet. It showed him producing his license with both hands in view. It showed that his posture did not change, and his feet did not move toward any officer at any point during the encounter. And it showed Harlan stepping forward and initiating the physical contact. Julian's arms went behind his back, without resistance, without a jerk, without any motion that could be characterized as combative under any standard of evidence Naomi had ever encountered in 17 years of civil rights practice. A second piece of footage came from a bakery 60 feet west of the transit stop, where an exterior security camera had captured a portion of the audio through its motion-activated recording system. The sound was uneven and partially obscured by passing traffic, but Julian's voice was audible on 3 separate occasions asking for the legal basis of his detention, and Harlan's response on one of those occasions was clear enough to transcribe without dispute. He told Julian that he did not belong in this part of the neighborhood. The local prosecutor's office reviewed both pieces of footage and withdrew every charge the same afternoon. The city's legal team contacted Naomi within the week and placed a settlement offer of $75,000 on the table, accompanied by a confidentiality agreement that would have prohibited Julian from discussing the terms or the underlying events. Julian rejected the offer for 3 specific reasons, all communicated in writing. The proposed amount did not require any modification of the policies that had produced the arrest. It did not acknowledge that the arrest report contained false statements, and it would have left Harlan on active patrol duty without any formal review. Naomi filed a federal civil complaint covering unlawful seizure, unreasonable search, malicious prosecution, and retaliatory defamation. Whitlock gave a public statement saying that one piece of footage from a commercial camera could not capture the full complexity of a law enforcement interaction, and Julian issued the only public statement he would make at that stage of the case. He was not pursuing legal action because he had been treated without courtesy, but because a fabricated police report had the power to strip any person of their freedom, and a person without a transit authority camera pointed at their arrest had no way to prove the report was wrong. 2 days after the federal complaint was filed, Naomi received a records production from the city's civil discovery process containing a list of 17 prior complaints filed against Harlan by members of the public, and the similarities between those complaints and the events of Julian's arrest were not subtle. Among the 17 complaints, 12 had resulted in no prosecution whatsoever. Not a reduced charge, not a diversion, but a complete absence of any criminal proceeding, which was the clearest available evidence that the stops themselves had lacked any legal foundation. In 7 of the cases, the bodycam footage associated with Harlan's unit had been reported as either malfunctioning or incomplete, a failure rate so statistically improbable in a department that had purchased and maintained its camera systems at substantial public expense that Naomi put a forensic technician on the records immediately. Multiple incident reports used language so nearly identical, phrases about subjects displaying furtive movements, refusing to account for their presence, creating a public concern that a comparison of the documents side by side read less like individual officer observations than like entries copied from a single template. Every internal investigation of those complaints had been assigned to the same review unit, and every review had concluded that the officer's conduct fell within departmental guidelines. Naomi shifted the legal theory of the case from individual misconduct to institutional liability. Not that Brett Harlan was a bad officer operating in isolation, but that the city of Bellwether had created and maintained a system that trained, rewarded, and protected precisely this kind of conduct. Internal Affairs investigator Elena Brooks had been assigned to review the incident with instructions to evaluate Harlan's behavior during the specific minutes at the transit stop, and not to extend her analysis to broader departmental patterns. Elena followed those instructions until she encountered something that made them impossible to honor. The body cam logs showed that the device had not malfunctioned, that someone had activated a manual audio suppression feature during the encounter, and that a subsequent deletion of the affected data segment from the primary server had been performed by a system administrator account linked to Whitlock's supervisory unit. The backup data existed on the infrastructure maintained by the camera system's third-party vendor and had not been touched. Elena accessed it through the same chain of custody process she would have used for any other evidence, documented every step, and secured the copy without telling her direct supervisor what she had found. The audio on the backup recording was intact, and it included the moment Harlan told Colin that he should write in his report that the subject had pulled his arm away first. Naomi's team was simultaneously building a picture of the city's Safe Corridor Initiative, a law enforcement program concentrating patrol activity in specific commercial zones that had never been publicly described as having arrest metrics, but whose internal email chains told a different story. Supervisors had communicated to officers that each shift should produce a documented number of proactive contacts in the designated areas, a term that meant stopping, questioning, and recording information about individuals, regardless of whether any criminal activity had been observed. And the program had no published criteria for which neighborhoods qualified, no public oversight mechanism, and no demographic reporting requirement. When Naomi overlaid a map of the addresses where Harlan had conducted his stops against a map showing the parcels that had changed hands in East Briar over the previous 18 months, the two maps aligned with the kind of precision that is difficult to explain as coincidence. Conrad Wexford had been described in every published profile as a visionary, a developer who saw potential in neighborhoods that other investors had written off, a businessman willing to commit capital to communities that the mainstream market had abandoned. His company, Wexford Urban Dominion, had completed projects in 4 Midwestern cities and was in the early stages of what its marketing materials called a transformative repositioning of East Briar, a mixed-use development anchored by high-end residential units, boutique retail, and a redesigned pedestrian streetscape that the renderings promised would replace decades of incremental decline with something that looked like prosperity. The problem, from a purely financial standpoint, was that the most desirable parcels in the target area were owned by people who had not yet agreed to sell them, some of whom had lived in the neighborhood for 20 years and had no intention of leaving. The correspondence between Wexford Urban Dominion and the mayor's office over the 22 months preceding Julian's arrest ran to several hundred pages. Once pulled through the discovery process, and reading it carefully revealed a pattern of communication in which the developer's representatives framed their requests in language that was always careful to avoid explicit direction while conveying unmistakable pressure. Complaints about what the emails referred to as street-level conditions, references to the importance of ensuring the corridor conveyed a premium environment prior to investor tours, and a recurring phrase about the need to address the presence of elements inconsistent with the project's target demographic, appeared throughout the correspondence without ever instructing anyone in specific operational terms. Mayor Vivian Carrington had received those communications and passed their substance to Whitlock, who had translated them into operational incentives. Officers working the designated zones were evaluated partly on the volume of proactive contacts they generated per shift, and that evaluation fed directly into the promotion and commendation systems that determined whose careers advanced. Harlan had generated among the highest contact volumes in the division and had received 2 formal commendations in the 18 months before the Julian Cross arrest. He was not an outlier in the system. He was the system's intended product. Julian understood, once the documents began to surface, that the night he had stood at the Briar Avenue stop had nothing to do with anyone knowing who he was. He had simply been standing in a location that a developer wanted to look different, and a police department that had been institutionally incentivized to enforce that preference had sent an officer reliably willing to do so. That realization did not make the 11 hours in the holding cell more bearable in retrospect. It made them more significant. Because if the federal card had not been in his wallet, if the transit camera had not been aimed at that corner, the report Harlan filed would have stood. A man would have had a criminal record, and the mechanism that produced that outcome would have continued operating, without a single internal voice raised against it. Naomi was careful in how she framed this argument for the court. She was not trying to prove Conrad Wexford had ordered Julian Cross arrested, because he had not. She was trying to prove that the city had accepted money and political support from a private developer, converted that developer's commercial preferences into police policy, and deployed that policy in a way that systematically violated the constitutional rights of residents based on their race and address. 3 days after she submitted the full evidentiary package, Elena received a letter informing her she was under review for unauthorized access to restricted personnel files. Miles Keaton, the city's chief legal counsel, advised Mayor Carrington in a closed-door session that the most important thing was to ensure no admission of systemic wrongdoing ever appeared in a signed document, and his strategy rested on 2 pillars: delay and character. The delay would be accomplished through procedural motions designed to narrow the scope of what the jury was permitted to consider, and the character campaign would be handled by a communications consultancy the city retained at public expense, whose first project was to position Julian not as a father who had been unlawfully arrested but as a federal attorney, opportunistically manufacturing a civil rights claim to extract money from city taxpayers. The consultancy's second project required access to Julian's personnel file, and someone with authorization to the Federal Document Exchange, established for the litigation, used that access to pull a sealed case summary from 3 years earlier, in which Julian had recommended against a full prosecution because the physical evidence had been ruled inadmissible. The summary was accurate in its facts, but the framing applied to it when it was given to a pair of local journalists was not, and within 48 hours, 2 stories described Julian as a prosecutor with a documented history of going soft on dangerous offenders. The problem for the city was that the list of individuals authorized to access that summary through the Discovery Exchange was not long, and Naomi submitted a formal inquiry to the court, requesting an investigation into how a sealed document had reached 2 news organizations on the same day. Julian read the articles the morning they appeared, and had been through enough litigation to know that a campaign of this kind meant the other side was worried, and a side that was worried understood what the evidence showed. That did not make it easier to sit at his kitchen table and know that people in his city were reading a version of him that had been carefully constructed to make him look like a threat instead of a witness. The city placed a new settlement proposal on the table, $1.2 million, a private acknowledgement that the body cam situation had been mishandled, no requirement to publish any internal documents, and no requirement to change the Safe Corridor program. Julian looked at the number and thought about what it would mean to sign it. The debt would be manageable. The administrative leave would probably end within weeks, and Maya would never have to answer a question about this from a classmate or a teacher again. He looked at her photograph on the desk and thought not about the night at the transit stop, but about the morning after, about sitting across from her and telling her that systems had mechanisms for correcting mistakes, and that they were going to use those mechanisms exactly as designed. He did not sign. He sent Naomi a 1-line message telling her to proceed. That same evening, Elena submitted her documentation through the city's formal whistleblower process, a channel that was supposed to guarantee protection from retaliation, but that had never been tested by anyone carrying evidence of this scope. She did it anyway, because the alternative was watching a deletion log disappear into a personnel review and a recording of Harlan, instructing a junior officer to falsify a report, go unheard by anyone with the authority to act on it. The depositions were scheduled over 3 days, and Harlan arrived, for his with the posture of a man who had been through departmental hearings before and expected this to follow the same trajectory. A few hours of uncomfortable questions, a union representative at his elbow, and an outcome that would resolve in his favor, because it always had. He maintained, under oath and on the record, that Julian had been standing in a known trouble area, that a member of the public had called in a concern, that he had properly identified himself and requested identification, and that Julian had become physically uncooperative in a way that required restraint to manage safely. He said this in a careful, practiced cadence, and he said it for 2 hours. Naomi let him finish. Then she pulled up the transit authority footage on a projector and played it at normal speed and asked him to identify the specific moment in the video when Julian had moved his body in the direction of any officer. The room was quiet for a long time, and Harlan said the camera angle was incomplete. And Naomi played it again and asked the question again, and he said the video did not capture what an officer perceives during a confrontation, and she agreed with him and moved on to the next exhibit. The next exhibit was an audio file from the vendor's backup server, and when Harlan's voice came through the room speakers, instructing Colin Webb to write in his report that the subject had pulled his arm away first. The deposition paused for 4 minutes while the city's attorneys conferred in the corridor. Colin had been deposed the previous day and had not been willing to lie a second time in a formal legal proceeding. His account of the arrest matched the transit video in every particular, confirming that Julian had been calm, had not resisted, had asked appropriate questions, and had been physically detained without any conduct on his part that could be categorized as grounds for arrest. Colin also testified that he had been told by a shift supervisor, the day after the arrest, that both officers needed to maintain consistency in their accounts to protect the department, that he had complied with that instruction once, and that he had declined to comply with it again. Elena presented her forensic analysis of the bodycam data system, and the modification log she produced showed 17 distinct alterations to records in Harlan's case files over 14 months, each one traceable to an account within the supervisory unit overseen by Whitlock. Whitlock denied under oath that he had directed anyone to alter or delete any data, a denial difficult to reconcile with a written message he had sent to a technical staff member 3 days after Julian's arrest, telling that person to handle the video matter before it became a federal story. The presiding judge denied the city's motion to exclude the policy-level evidence from the jury's consideration, ruling that the safe corridor documentation and the pattern of prior complaints were directly relevant to the question of institutional responsibility, and the city's insurance carrier sent Bellwether a formal advisory, noting that if the case proceeded to trial, the anticipated damages range was likely to exceed $10 million before legal fees and the cost of any court-ordered reforms. Conrad Wexford's office quietly let it be known that the developer would need to reconsider the project's timeline if the city were compelled to make the safe corridor correspondence part of the public record. Mayor Carrington convened what her office described as a final mediation session in a conference room on the 9th floor of City Hall, with Keaton on one side of the table, Naomi on the other, and a federal mediator overseeing the process. The city's opening position was $4 million, a private internal review of bodycam data policies, no requirement to alter any active program, no public disclosure of the safe corridor documentation, and a non-disclosure agreement covering the material terms of the settlement. Naomi listened without interrupting and then laid a single sheet of paper on the table. Julian's conditions for any agreement included the complete, unredacted public release of the bodycam audio from the backup server, permanent expungement of the arrest record and all associated filings, formal dissolution of the proactive contact metrics embedded in the Safe Corridor program, establishment of an independent civilian oversight body with authority over bodycam data retention and access, a mandatory reinvestigation of all 17 prior complaints associated with Harlan using the full evidentiary record, written employment protection for Elena Brooks and Colin Webb against any adverse action related to their cooperation, and public disclosure of the financial relationship between the Safe Corridor program and the Wexford Urban Dominion development proposal. Keaton told the mayor in a side conversation that she needed to understand what proceeding to trial would require. Every named official from the department's command structure, including herself, could be called as witnesses. Their communications would be entered into evidence, and the jury would hear the body cam recording in open court. The city council held an emergency session that ran for 6 hours and included 2 recesses, and a closed caucus in which several members made clear they had not known the scope of the Safe Corridor program when they had approved its budget line as a public safety initiative. At the end of the session, the council voted to authorize a settlement of $6.8 million, and the figure was not arbitrary. It reflected the calculated value of the unlawful arrest itself, the 11 hours of detention without cause, the malicious prosecution, the reputational damage produced by the official press statement, and the leaked personnel document, the retaliatory conduct of the city's communications campaign, and the extended period during which the city had pursued concealment rather than correction. The settlement agreement included every item on Julian's list. The city did not admit that every officer in the department had behaved improperly. It admitted that the department had failed in its obligations to train officers in constitutional standards, supervise their conduct, preserve evidence as required by law, and investigate complaints honestly when lodged by civilians. Less than an hour after the vote, a council member quietly provided Naomi's office with a document showing that Whitlock had given sworn testimony to the council's public safety subcommittee 8 months earlier, in which he had stated under oath that no body cam data from Harlan's unit had ever been altered or deleted, and the document was forwarded to the United States Attorney's Office the same afternoon. Graham Whitlock was placed on administrative leave within the week, as the independent investigation confirmed that his unit had authorized the deletion of body cam data, and that his sworn testimony to the City Council contained material false statements. He resigned before the investigation reached its formal conclusion, issuing a statement through his attorney that attributed his departure to the stress of prolonged litigation and said nothing about the deletion logs or the deposition audio. The resignation did not close the question of criminal liability. It simply transferred that question to a different proceeding in a different venue. Brett Harlan was terminated from the Bellwether Police Department on 3 separate grounds: filing a false incident report, tampering with evidence in his body cam system, and directing a subordinate officer to provide a false account of events to supervisors. And the department forwarded his personnel file and the underlying documentation to the state's Law Enforcement Certification Board, which held authority to revoke his certification and prevent him from being employed as an officer in any jurisdiction within the state. Vivian Carrington announced 3 months after the settlement that she would not seek a 3rd term, citing the toll the preceding year had taken on her family, and Conrad Wexford's company formally withdrew its letter of intent on the East Briar project, while the institutional investors who had been briefed on the development began asking detailed questions about the company's due diligence practices regarding municipal relationships. Elena Brooks was reinstated to her position with back pay, received a formal departmental commendation for her handling of the evidentiary chain of custody, and was appointed to the Civilian Oversight Board, created under the settlement agreement. Colin Webb received a formal reprimand for his initial failure to report what he had observed, a consequence he accepted without contest, and the record noted his subsequent cooperation and the truthfulness of his testimony in resolving the matter. Julian returned to his position at the federal prosecutor's office after a review panel determined that he had at no point used federal resources or authority to advance the civil case. A conclusion that surprised no one who had worked with him, because the self-imposed firewall he had maintained throughout the litigation had been, if anything, more rigorous than the rules required. A portion of the settlement went into an education account for Maya. A portion went toward establishing a legal assistance fund for individuals in Bellwether who had been arrested without cause but lacked the resources to retain private counsel. He named the fund after no one, and he described its purpose simply: to ensure that the absence of a camera pointed at the right corner at the right moment did not have to determine whether justice was available to someone standing at a bus stop. A year after the settlement was signed, Julian walked back to the transit stop on Briar Avenue on a Friday afternoon, and nothing about the street required him to announce himself, explain his presence, or demonstrate that he belonged there. The hardware store was still operating, the laundromat still occupied its corner, and the residents who had been characterized in development documents as inconsistent with a target demographic were still living in the houses and storefronts of East Briar, because a chain of events set in motion by one man standing still at a bus stop had made the financing of their displacement considerably more difficult to arrange. The Safe Corridor program no longer existed under that name or any successor name, and beside the transit shelter a laminated notice had been installed describing, in plain language, the legal rights of any person approached by law enforcement in a public space. Maya stepped off the bus at the end of her last school day before summer, and she asked her father whether $6.8 million had made him feel like everything had been corrected. He told her that money could compensate for harm but could not unhappen, 11 hours that should never have occurred, and that the more important measure was whether the next person standing at this bus stop would have to prove they were a federal prosecutor before they were treated like a citizen. They walked home together. Across the street, a young officer had pulled over to speak with a shop owner. The camera on his uniform was recording. The conversation was ordinary, and no one was asked to leave the neighborhood where they lived. The story ended at the same bus stop where Julian had once been put in handcuffs. Not with revenge, but with a city that had finally been forced to understand that the rights of any person waiting for their child do not change with the color of their skin, the address on their license, or the title on a card in their wallet.